Hi, and welcome to another riveting episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we are talking about the scope of search in warrantless arrests. Cases that should have gone to the Supreme Court of Canada, but didn't. In Canada, the law is that if a police officer arrests a person for an offense, they are entitled to search that person and the surrounding areas to obtain evidence related to the arrest. In Damian Pearson's case, he was stopped for impaired driving. The police searched his vehicle in the course of arresting him for the impaired driving offense and ostensibly to find evidence related to impaired driving, and ultimately ended up finding evidence that connected Mr. Pearson to 2 murders. He was charged and later convicted of first-degree murder on one and second-degree murder on the other. At trial, Mr. Pearson argued that the evidence that was obtained against him as a result of his vehicle search was obtained in circumstances that violated his rights because the search wasn't really related to impaired driving. And that's a really interesting issue. As somebody who deals with a lot of impaired driving cases, it's not often that the police find evidence related to the impaired driving offense in the vehicle. Sure, there might be liquor containers or receipts from bars, but if you're arresting somebody for impaired driving, you already have, supposed to have anyway, reasonable grounds to believe that their ability to drive is impaired by alcohol. You'll have balance problems, slurred speech, odors of liquor, admissions of consumption. You can usually tell when someone is drunk. And so, why the police felt it necessary to search the vehicle, and why that search would be related to the arrest, is really concerning, especially in these types of cases. But it also opens the door for more searches to be conducted of vehicles in circumstances where they aren't really related to the arrest after all. The Supreme Court of Canada needed to chime in here to say, hey, if you're arresting somebody for one thing, you can't use that just as a mechanism to gain evidence for something else you suspect them of doing. The Supreme Court of Canada should have put a close on this, because a lot of times, unfortunately, warrantless arrests can be done without the proper grounds in circumstances where they are unlawful, and then evidence is obtained that is used against somebody on a very serious offense, and that evidence may not automatically be excluded from trial. There needed to be clearer guidelines about how far police can go in the course of arrests for impaired driving versus how far police can go when they're relating their search to the reasons for the arrest. And in this case, it was a good opportunity for the Supreme Court of Canada to put that power, that warrantless search power, contingent with a warrantless arrest, in a box that it can be used in appropriate circumstances. It's a shame we're going to see a lot more warrantless arrests, a lot more unlawful arrests, and a lot more unlawful searches as a result. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. My name is Kyla Lee. I'm a lawyer at Acumen Law Corporation in Vancouver. Thank you to Brazen Bull Creative, who have helped enormously with putting together these videos, and I hope you subscribe, follow, and like, and share with your friends.